Okay, are we on? All right.
Hello.
Hi. Welcome to the Thursday Colloquium series. Michael Hart couldn't be here, so asked me to step in, which is why I'm here. And we are delighted today to have Babak Tehranchi with us to speak. Babak is an alumnus from the University of Arizona and the College of Optical Sciences, although I think it was still the Optical Sciences Center then, right? So he's earned an MS degree in optical sciences and electrical engineering, and then a PhD in optical sciences in 1996. And then he went out into industry for 11 years and worked at Eastman Kodak and at Verance, and gained some industry experience, but then decided that I guess that just wasn't interesting enough. So he had to pile on and went and got a law degree in patent law from UC San Diego?
University of San Diego.
University of San Diego. And is now a partner with Perkins Coie, which is a big law firm nationwide, and he is a partner in the intellectual property practice. So his area of expertise is in wireless technologies, optics, digital rights management, software, electronics, medical devices, digital watermarking, semiconductors. Let's see, what have I missed? A lot. He's got a good broad background in electronics and optics. And he's also done patent portfolio evaluation as well as patent prosecution. So he has many things that we can learn from him. And please help me welcome our speaker today.
Thank you, Amy. Can you guys hear me? Thank you, Amy, for the kind introduction. I'm very happy to be here. Last time I was actually inside the building was 20 years ago. That's when I graduated in 1997 from optical sciences. Just to give you a little bit more detail about my background and what made me go into law, it wasn't because I needed more stress, but I'll kind of tell you my story, and maybe this is something that one of you guys along the line would decide to do. So I was in Tucson for 10 years, 11 years, did my bachelor's and master's in the electrical engineering department, then made the best decision of my life, came to Optical Sciences Center at that time, as it was called, got a PhD, and when I was going through the courses and doing my research here, I had no intention whatsoever to become a patent lawyer or get involved in intellectual property. The only thing that happened when I was here is I was sitting in the lab on the 6th floor, and my advisor walked in to the office, to the lab, and said, Babak, here is a patent lawyer. We need to work with him to write a patent for us. So that was my first introduction to patents, and I'm sure some of you guys may have had similar situations or will have that situation. Obviously, the faculty here, as I know some of you guys, and I've looked at the resumes, almost everyone has been involved in patents in one way, shape, or form, and some of you have many, many patents. So what I did, I graduated. I worked for Kodak, research labs, great place to work. Worked there for 4 years. And I wasn't bored, but Kodak wasn't doing well financially. So I moved to a startup with the hopes of making a lot of money. And this was right before the 2000 bubble. Well, I didn't time it quite right. The startup is still a startup after 16 years. They're still in business, though. So that's the good news. But what happened is 5 years into that job, which was basically I was doing copy protection and digital watermarking for multimedia content. Another company sued us. The CTO of the company came to me and said, Babak, I don't have time to deal with the lawyers. You go deal with them. And that was kind of a trigger that I got into this field. I dealt with the lawyers. Eventually, the case settled, And I realized that, law could be interesting. I went and passed an exam, became a patent agent. I said, okay, now I know about patents, and it's easy to pass that exam in case I need it later on. I became a patent agent, and that company told me, well, you're a patent agent now. Why don't you write our patents for us? So I was doing the engineering work and writing patents at the same time. Then I got this crazy idea of why I should go to law school. So a third thing was added to my plate. I was doing an engineering job, writing patents, and then went to law school at night. Took 4 years, got my degree, and started working for a law firm full-time, exclusively doing patent prosecution. I'm a partner now at Perkins Coie, and as Amy said, this is a very large law firm. We have over 1,000 attorneys in different areas of law, about 250 of them in intellectual property. We work with different kinds of clients, with universities, with national labs, with large companies like Intel, Google, and with small companies and startups. So it's a bag of things, mixed clients that I work with. And what I want to tell you now is just a little bit about what I do. Because when people hear I'm a lawyer, they kind of look at me funny, and they may be thinking, who is this guy? And just to tell you what I do, a big part of my job is probably 60% is to talk to inventors, get their ideas, scientific principles sometimes, narrow it down into something that is understandable by the folks at the patent office, and get patents for them. And it's a joy for me to work with different types of technologies and try to get a patent for those guys. The other part of what I do is sometimes the firm clients come to us and they say, we want to acquire this company. Why don't you guys do what is called due diligence? And that involves looking at the business aspects of the deal, and they ask me to look at their IP and the patent portfolio. So part of what I do is I look at these patents from a legal aspect to see whether there are any legal issues with them, and also from a technological aspect. Are these patents relevant to the technology? What is the future market for these patents? Who are the competitors? And sometimes we hire technical experts, like some of you folks that are sitting here, to help us do that due diligence. And finally, the third thing that I do is I go to the patent office and, through a process that's called inter partes review, invalidate some of the issued patents. And that case arises when our clients get sued by a troll or by somebody else. Instead of going through this long 2-3 year process of litigation, they have an option to go to patent office. So what I do is I look at the prior arts, I try to make arguments, hire experts, and it culminates with me standing in front of 3 judges at the patent office, no jury, so that's a blessing, and tell the judges why these patents are not good patents. With that long introduction, I'm going to get to the nitty-gritty of my presentation. And I really had a hard time trying to put this thing together for about an hour worth of material, because there's so many things that's going to come to you from left and right. Some of it you already know. And some of it may be a different point of view that you weren't exposed to it before. But what I wanted to convey here is that almost every one of you in this room is going to be eventually dealing with IP, either as an inventor or as an expert or as a licensee or licensor of a patent, or, God forbid, as an attorney or patent agent. Interestingly, there are 4 people that I found out from my graduating class that are patent attorneys. they worked in the industry and they went back and became either an attorney or a patent agent, and they're working full-time in the patent area. Or you could be sued, right? That could happen. Either you, as part of a company, or maybe personally if you own the patents or own a technology. Or maybe you want to sue someone. With that, I'm going to tell you a little bit about what the world of intellectual property is typically broken up into. I am not an expert in copyrights, trademarks, or trade secret. So I'll just tell you a little bit about them. The chances are, if you have questions about copyright or trademark, you are either being sued or you want to sue someone. Because you don't really need to register those. The issues are really different. My focus will be on the patent issues. And I'll start with just a brief introduction to copyrights, which you may or may not know. It's a kind of protection for a material, original works, that is fixed in a tangible medium. So what that means is an oral presentation like what I'm doing here. If it weren't on a computer disk, that would not be copyrightable. It applies to publications, your journal publications, musical works, sound recordings, movies, etc., etc. And as I said, you don't really need to register it. At the moment that you put it on a memory, if you store it or you fix it somewhere, then it becomes your copyright. But if you want to sue someone, you need to register it after the fact, so we can sue someone. Due to a lot of lobbying by movie industry folks, it has a pretty long life. It lasts for the life of the author plus 70 years. So they didn't want the movies, the Disney movies, to get copied. That's why. And there are exceptions to it under fair use, which if you use it for research or education and etc., you are not going to be infringing a person's copyright. The other kind of universe is a trademark. And a trademark is a word, phrase, symbol, or a design that identifies a good, something tangible that you sell. So Microsoft, Adobe, these names are copyrighted. And a similar idea is a service mark, which instead of a good, it applies to a service. So for example, UPS, they're in the business of delivery of things, so they could put their service mark on their vans. Interestingly, there is this thing called a sound mark. They call it a sound mark. So MGM Studios, when you watch the movie, there's a lion that comes and roars. Now I think it's Sony Studios. So they have a sound mark for that roar. Again, you don't need to register for it. However, the catch is you have to be using it in a business. And if you don't use it, you'll lose it. The time period could be anywhere from 3 to 5 years of non-use. What I forgot to do is I have about 20 of these printed out. So I'm just going to pass it out. If you want to take one, please go ahead. If you don't and you want a copy of this, just email me and I'll send you a copy. Yes?
So when you say register things like copyright and trademarks after the fact, are you able to say that something that's just give you a your idea, etc.? What if you wanted to do before to take preventative action to not have it stolen or have to go through the process of suing or getting sued?
So they can't steal it. I mean, if they steal it, you have to sue them. That's the only way. Right? So, and in order to sue them, you just need to have this thing that says it's registered. So even after you register it, they can steal it. But eventually, you have to go to court and resolve that situation. A trade secret, it's a formula, a pattern, a compilation, a program that you keep it a secret. There are procedures that you have to go through to keep that a secret. An example, which may or may not be true, is the Coke's secret formula, or Colonel Sanders' fried chicken recipe. The composition of WD-40's chemical formula is not known. There are many generics in the market, but nobody knows what that formula is. It's a lubricant. So it's, for squeaky door, and it's headquartered in San Diego, so that's why I have it up there. You can go to court sue someone for misappropriation of trade secrets, that they stole it from you. And if they say that they independently discovered it, then that's a good defense, and they won't be convicted. All right, so I just knew that much about copyrights, trademarks, and trade secrets. Now I'll turn to patents. You may or may not know it's in the Constitution. Article 1, Section 8, Clause 8, it actually says that inventors, they could get a patent for their discoveries. Well, it really says that Congress can pass laws to give them credit for their inventions and discoveries. Same with copyright. So as a root, the root comes from the Constitution, but it's governed by statutes, regulations, and treaties, which is not up there. So statute is something that the Congress passes. Regulations is something that an administrative agency like the USPTO, U.S. Patent Office, passes or enacts. And treaties could be international treaties. The most well-known statute in the patent law is 35 U.S.C. 101, which says what is patentable. Any new and useful or any new and useful improvement of something could be patentable. And there are 4 categories that are specified. A process, which is a method of doing something. A machine, which is a device for doing that process. A manufacture. This is kind of vague. You could think of it as if you come up with a new substrate that has certain properties, that would be a manufacture. And composition of matter is the chemical composition of something. Another important statute is 35 U.S.C. 154, which says how long you're entitled to a patent. It's 20 years for a utility patent, and we'll go a little bit later, we talk about what the different types of patents are. And it used to be 14 years for a design patent. But based on a treaty in 2015, now the inventors get 15 years. And basically what that is you are getting a limited monopoly for in exchange for teaching your invention to the public. So that's the whole philosophy behind patents. And these statutes and regulations, they are changed constantly by courts. This is what makes me have a job here. So some of the things that courts have said, okay, these are exceptions to the previous statute. So these are not patentable. Laws of nature, natural phenomena, and abstract ideas. Now, the last one is really vague. What is an abstract idea? And this is a subject of a lot of litigation and a lot of headache for a lot of inventors. For example, software patents, patents that deal with software exclusively, they could fall under an abstract idea. And we deal with that in certain ways. One of the things about patents, this is really, really important. When somebody is not involved in patents and they just heard about patents, this idea kind of bugs them a lot, is that a patent is an exclusionary right. So it's not an affirmative right. What it does, it excludes others from selling, offering to sell, use, make, or import that invention. And it also precludes others from inducing somebody to infringe your patent. But it's not a right to practice your invention. So just the fact that you got a patent on your certain technology, that doesn't mean you can go and sell that product without having to be worried about other patents. There will be others who have similar patents in the similar area, and they could come and stop you. They could come and sue you. So this is really important. And when I talk to some startups, they say, "Oh yeah, we have a patent on this, so we're good," right? No, that's not the case at all. The other thing to notice is that there is no patent police. So if you have a patent, it's not like somebody's going to tell you, "Yes, companies X, Y, and Z are infringing your patents, and here's the money. We're going to give it to you." No, you have to go out and look for infringers, and then if you cannot resolve it amicably, you have to go to court to resolve that dispute. Okay, so a lot of theory up to this point. What is it practically? On a day-to-day basis, a patent really is a company asset. So when companies go out of business, they're not going to get much for their furniture or old computers or whatever equipment they have, but they could get a lot for their intellectual property. So it's a company asset that stays with the company. You can buy it or sell it. You could license it, transfer it. You could use it as a shield. So you could prevent others from entering your market. Or you could use it as a sword, and you could use it in negotiations to say, "Okay, I'm going to license my patents to you in exchange for giving me the license to your patents." And before getting to the next slide, I also wanted to tell you a little story about, and these are rare cases, that patents are always not for a monetary purpose, right? You're not always trying to make money from a patent. So one thing is a teaching tool, right? So you're supposed to teach others what's the state of the art and what you're doing. The other thing is you can prevent others from doing something. And the story here is, this is a true story. San Diego Zoo is a client of our firm. And they are working extremely hard on methods to prevent extinction of the northern white rhino. There's only 3 more left in the world. The poachers, they've killed them off for their horns. And there's only 3 more left in captivity. But for some reason, they can't reproduce. There are no babies. And they're working on all these different in vitro techniques and artificial insemination and so on and so forth to try to make babies. Now, they've been talking to us to see if we can patent the technology, not because they want to make money, but because they're afraid that if their technology, their know-how gets into the hands of poachers, they would set up their own labs, they would make rhinos, kill them off, and take the horn. Which ones? The rhinos. I will have to examine that. But no, they think it has to do with their diet, perhaps, or maybe the attractiveness of the others. I don't know, but. Going back to the practical aspects of a patent, you should think of a patent as a bundle of rights. So it gives you different options. And you can only decide to trade or use one of those fibers in the whole bundle. This is an example of a patent. Actually, this is my own patent when I worked at Kodak. And the only reason I have it here is that if you look at the ownership rights of this patent, it was filed in 2000. At that time, all the inventors, they transferred their rights to Kodak. Then Kodak got into trouble, financial trouble. They wanted to get a loan. They used that as a security deposit to get a loan from Citicorp. They were able to somehow pay the loan back. Maybe they were in bankruptcy. And then they transferred all their rights to another company called Intellectual Ventures. This patent expires in 2022, so there's still quite a few years left. And nobody knows what's going to happen here. They could use this patent to sue someone or sell it again or whatever they want to do with it. The other interesting thing is, after it expires, it doesn't go away. It becomes a zombie. And what that means is the patent owner gets 6 years. And during that period, they could still sue someone and collect back damages. So, you know, your patent is going to survive for a long time. This slide is, I think, important for startups and for universities. You know, patent ownership is a little bit different than property ownership. Well, not a little, but there are many different ways that it's different. One of the ways is you could have different owners for a patent. In US, if there are no other legal documents, when you file the patent is owned by the inventors. Typically what happens is, if you're working for a company, you are obligated contractually to transfer all your rights to the company. And oftentimes, if you have a decent law firm, or any law firm perhaps, they file a document with the patent office that says you've transferred your rights to the company. There could be situations where there is a joint research project with 2 different companies, 2 different universities. You could have a contractor that's working on some aspects of the patent. You could have the investor who says, I'm paying for this, I want to have some kind of ownership. Or the government, US government, could have rights. So it's really important to figure out who owns this patent and how much of it they own, because of this quirky 35 USC 287C, which says if they're joint owners of a patent, any one of the owners, without the consent of other owners, they could do whatever they want with the patent. So if you and I jointly own a house, I can't just go sell my portion of it. I have to get together. We have to get together and sell it together. With patents, that's not the case. This one owner can go and license the patent to somebody else. So that's something to keep in mind in terms of getting the ownership interest straight. And I've been involved in cases where this has come back and caused a lot of headaches for us. All right, so let's talk about money. There are a lot of lawsuits, patent lawsuits. And here I pulled some examples. First one you might have heard about is Apple versus Samsung. It was over a 3 design patents. The original damages were, I think, $1.2 billion, and then it got reduced to $400 million. But if you go down the list, you see there are universities that are involved. Carnegie Mellon, this was in 2012. This was some error recovery mechanism for magnetic storage. 1.17 billion, the parties decided that they're happy with 750 million. And these are court decisions. So this is a verdict in litigation. Some of these, 53 million. So again, Cornell University. Because of such high stakes, there's a lot of value put on important patent portfolios. And by patent portfolio, I mean you got a bunch of patents, you put them together, and it says, here's my portfolio. If you have a single patent, unless that's a really, really, really fundamental patent, you won't be able to sell it. So typically, we deal with a bundle of patents. Look at these acquisitions. And if you look, HP bought Palm patents. Do you seen any phones by HP or Palm operating system? No. So $1.2 billion basically flushed. Right? Maybe. I don't know. I don't know. Maybe they use it for some other reason. But $4.5 billion for 6,000 patents. The Nortel portfolio. They went under. They went under, and what was left of it, $4.5 billion. That's a pretty good valuation for a bunch of patents. It was so much that really 6 companies had to come together to be able to pay that sum. And I have 2 down here. These are acquisitions by Intel. And the reason I have them here is because I was involved in both of these deals. And basically, I was evaluating the technical aspects and the legal aspects of these patents. We'll see how useful they're going to be for Intel. In terms of optics, what's going on in the world of optics? I had 2 difficulty trying to get this data. One is there's no category called optics. As you know, people ask you, what are you studying? Optics. What does that mean? Glasses? You're a doctor? What does it mean? Well, so some of this, it's, not very exact. These are approximations, but whoops. What this plot shows, these are patent portfolio, the number of patents sold per year. So in 2011, I could only find about 300 optics patents, optics-related patents that were sold. In 2015, it shot up to 2,500 patents. In terms of what the technology areas that they dealt with, you see that display systems is kind of dominating. By the way, these are the largest portfolio sales in optics for that year. So in 2015, there was a portfolio of about 1,000 optical fiber patents that were sold in a transaction. I don't have any numbers for these deals. They're not public. But what I do have, I found some other deals that I could find some numbers. And if you look at these, in 2013, for example, there was a portfolio of digital imaging patents that sold for $525 million. If you divide that by the number of patents, you get something around $500,000 per patent. So, and it ranges, right? So these guys are 87,500. These guys are 600,000. As I said, the reason you got these large numbers is because it's a portfolio. You won't be able to get anything close to these numbers for single patents or 2 patents. So what's being filed out there in terms of optics? This is kind of some of the trends that I was able to find in the past 5 years. These are all the optical categories. And as you can see, image analysis, these are kind of image processing, a lot of software type, algorithm type patents. They dominate by about 36%. Followed by illumination systems and LCDs and other systems. You see the numbers here. And what's also interesting to note is if you look at the whole universe of patents that are being filed, optical patents only make up 5% of the patent filings. So it's not a huge percentage, but it's a respectable 5%. So it's not too bad. All right. Any questions so far? All right. Let's get under the hood. Just talk about what a patent is, what's the life cycle, and other good stuff. this is a typical scenario where kind of a life cycle of a patent. Typically, you start with a provisional application, especially at the university setting. That gives you a year. It's a grace period to file your non-provisional application. And 6 months after you file your non-provisional, assuming this is a year, or 18 months from the provisional, your patent gets published. Then from the time you file your non-provisional, it takes anywhere between 1 to 5 years for the patent to issue. During this process, what we do as attorneys, we get correspondences from patent office. We go back and forth. They say it's not patentable, it's not novel, it's an obvious variation of the existing art. And what I do is, on the phone, in writing, in person sometimes, I talk to them and try to convince them, no, you should issue this patent with some changes. And the life of a patent is 20 years from the time you file the non-provisional. So really, you get this one bonus year from the filing of the provisional application. What's important is really your rights become vested when the patent issues. Prior to this point, you pretty much have 0 rights. Well, it's not quite 0. There is some sort of we call provisional rights that you could get when your patent application gets published. And what that means is if it gets published and then eventually it becomes a patent, then you may be able to go back and collect some damages for this time period. Now, when a patent is issued, you're pretty much done. What that means is there are a couple of ways that you could maybe tweak that patent a little bit more, but it's called a reissue, but we're not going to talk about that because it's not very common. But practically, you're stuck with whatever claims you have in the patent. And one of the things that you can do, and in my opinion, you should do, before the patent issues, the day before even, you would file what's called a continuation patent. What that allows you to do is to keep this patent alive. And the continuation goes through the same examination process, gets issued as a second patent. And you could, right before the second patent issues, file another continuation, and so on and so forth. The caveat is all of those continuations, they expire right at this point. So really, you can't extend the family life beyond this point. But the important thing is, when you have a pending continuation, that allows you to go back and adjust your claims. You can't change the technical description of the patent, but you can change your legal rights by changing the claims. And we'll get to that a little bit later about what a claim is and what a claim is not. The other point is between the time that a patent issues and a patent expires, you have to pay what's called maintenance fees every 3.5 years. And if you don't pay those maintenance fees, your patent expires. And also during this time, somebody could challenge the patent, take it to court, and invalidate it. What are the different types of patents? Almost 95%, or I don't know what the number is, but a large number, they're utility patents. It's just your run-of-the-mill regular patent applications, or patents. And I have here 3 patents, 3 optical patents that I'm going to send around. Please take a look at these. I haven't picked these because they're good patents or bad patents. I have no comment about the quality of them, especially because I'm being recorded. What I can tell you, the first one was issued last month. It comes in through an original Japanese patent that came to US after being filed in Japan. It's about adaptive optics. You can look at the figures, look at the text a little bit, look at the claims, see what the style they have. Not necessarily the best style. Okay, that's all I'm going to say. And the other 2, one of them is a university. It was a research was done at UCSD, which issued patents. And the third one is actually, this is my patent that we talked about, the transfer of rights. I just have it in there so you can see this is what a kind of a company patent would look like, and kind of compare and contrast the different styles. When you look through this, a patent has a textual description, some drawings, and there's this kind of quirky thing in US patent law called the best mode. It's been weakened a lot, but it's important to note, and this is probably a note for patent attorneys. I don't think you guys need to care about it, but in exchange for giving you the 20-year exclusivity of the patent, the US government expects you to describe the best way that your invention can be practiced. So at some time, they wanted you to say exactly what it was, but now they don't need you to point out to a section and say this is the best mode. They kind of rely on you to say, all right, I have the best mode in there and I've described it. This is unique to US law. It's nowhere else. The important thing about a patent is its claims. And the claims are really what defines the metes and bounds of a patent. You know, one of the mistakes that some people could make is that they read the technical description of a patent and they say, yeah, I know what this patent is about. I'm not infringing this. Or, yeah, I'm infringing this because it describes my invention or our product. That has very little bearing on whether you infringe it or not. It's the claims. And usually the claims are written in a way that are broader than the description. And I've argued for a court that what's described in the detailed description, technical description, is an example, one example of how this invention can be practiced. So the scope of the claims are usually much broader than what you've described in the specification. So I wouldn't just trust on, look at what's in the technical description to see what a patent is about. But, obviously what you are claiming has to have some sort of a support in the specification. It doesn't have to be an exact verbatim support, but it has to be described in some way. I work with UCSD, and I work with other universities. And I think now there's a good level of sophistication about what a patent is and how a patent should be written. But, it's very important that it's not an academic paper. If you get an academic paper and just take the title out, do some minor changes, file it as a patent, big X. No good. Because in an academic paper, what you're doing, you are describing the foundation. You're talking about what other people have done. And you reference all those different things. And then you say, okay, and what I've done here is I've added this little pimple on top of what was previously done. If you write that in a patent, your patent becomes a lot less valuable. Typically, what you need to do is don't say, forget about describing the prior art systems. That's the patent office's job to look at their databases, figure out what's out there. Your job is to describe what your patent does. Don't tell what the patent does not do. Don't say, these are the limitations. These are my future work that I still haven't done. Those are all red flags. How much of your data and simulation results and that sort of thing you include in a patent specification, that's kind of a judgment call. So you need to consult with your attorney to see, okay, do I need to put in all these MATLAB plots or data that I've provided, that I've created or not. But it's not a technical it differs in many ways from a technical publication. And at the end, we add claims, and they're really awkward to read. And sometimes they say the more vaguest claims are the best ones. You know, there may or may not be some validity to that. Just a quick overview of provisional applications. It's a unique tool in US patent law. It gives you a 1-year grace period. You don't have to dot all the I's or cross all the T's in your provisional application. It doesn't get examined, but you need to have a pretty good description of your technology and some claims in there. There was a change in patent laws in 2013 that makes having a good, meaty provisional application even more important. And we'll talk about that maybe a little bit later if there's time. But it's an imperfect filing that you do. And it gives a company or the university about a year time frame to decide whether you really need to go forward with your filing a non-provisional application. How am I doing on time? 10 minutes. Okay, so just a quick note on the change in patent laws in the US. Happened in 2013. We're trying to get more harmonized with what's going on in the rest of the world, which is first to file. So if you publish your application and then try to file an international application, then you lost your rights. In US, it was something else. You could come up with your invention, keep it secret, sit on it for 5 years, and then if somebody else files a patent in that area, immediately you file your application, and you would go back, bring out your lab notebooks, take it to the patent office, and say, I invented it first. I have the patent rights. That changed. Now we have what's called Firstinventortofile. And here it is. I think the best way to describe it is looking at this. At time point 1, inventor number 1 comes up with an idea, does not file a patent, sits on it. Later, inventor number 2 comes up with a similar idea and files a patent. And then inventor number 1 tries to file a patent at this point. They're not entitled to it. In the old days, in the old regime, he could go back and say, but wait a minute, I came up with the idea here, and here are all my lab notebooks. No more.
If they work together, it's a little more complicated.
That's right. That's right.
Can you use the lab notebooks of the first inventor to invalidate the second inventor?
No. But here, you can do it here. And you still have, it's not quite harmonized with the rest of the world because of this 1-year grace period. So in this scenario, inventor number 1 comes up with the idea and publishes it. So it's out in the public domain. And inventor number 2 comes up with that similar idea and tries to file a patent. This guy files a patent within 1 year of this initial date. So you have 1 year to file your patent. You are entitled to your patent, and this guy is not, because this publication comes before his filing date. So you're good here. So in a way, you should publish, you know. But make sure you file a patent within a year. And also remember, when you publish, after the publication, you lose your international rights. So you cannot get a patent in Germany or Japan anymore.
Can you get a provisional after that 1-year period, or by the end of that 1 year, you need to get a patent?
Provisional. You can file a provisional, any kind of filing. Right. Now, talking about international filings, there are different ways. The typical way is to file what's called a PCT application. A PCT, more or less, is a holding tank. In some ways, it's similar to the US provisional application in that it doesn't get examined. But it gets published, and there's a search report that gets issued along with it. So there's search authority, PCT, they do a search. They tell you what are the prior arts out there. It gives you about two and a half years to decide if you really want to pursue your patent rights. One of the things, and this is really for companies, and perhaps in a research setting, you have two decision points. The first one is, after you've developed your technology and it's gotten to a place that you think, you have something, you got to make a decision if you want to file a patent or not. You may want to keep it a trade secret. You may not have any money. So you may be working for a nonprofit organization. So there might be different reasons why you would not file a patent. But if you decide to file a patent and you have that patent drafted, then the second decision point is where to file. Do you want to file it internationally? And if you do, which countries? This diagram shows you, again, a typical scenario where you start with a provisional application, and one of your choices is to file in the US, and simultaneously you could do these two actions as well. You could file a PCT application, which allows you to later on file into 152 different foreign countries. Oh, sorry, this is a PCT route. So after you come out of PCT, you could file in different countries, get your patent, or you could directly go from within a year, file in your country of interest, in Germany, Japan, China, wherever you want. And the sooner you make this decision, the less money you're going to spend, right? So if you know at this point that you're only going to file in the US, it's great. You just pursue this, you're done. If you know you are filing in Japan and US only, there's no need to go through this PCT process. It's very expensive, and it takes a very, very long time. You file in US, you file in Japan and Germany, and you're done with. But the longer you postpone that decision and say, okay, let's just file a PCT, and then we'll figure it out after 30 months, then you're going to end up paying more money because you filed this PCT and all these other things. The other point is this is a very expensive process to get foreign patents. Yes?
Is there any other downside to just going through the PCT application other than the money aspect? Like the U.S. utility application versus the non-provisional, is there anything you lose besides time and money?
Those are the main points. One other thing is, if you really want to get a quick patent, sometimes, you can expedite this. You could immediately get a U.S. patent. And, for startups, that's really important, right? They want to tell the investors that I have a patent. And, a lot of our clients are really, really anxious to get their first patents. So where do you want to file? It's one of the things is you want to file somewhere that has a pretty good legal system. And as an example, in Japan, they have a really good legal system, but there are not a lot of lawsuits with big awards in Japan. A lot of things get settled and through negotiations and arbitration and so on. So filing in Japan may not have a lot of value if you don't have the money to do it. And it also depends on your technology. So we'll talk about that here. You got to see where is your manufacturing base, where are you selling your product now that you could have potential infringers. Where are your competitors filing? That's usually a good indicator which markets are going to be important, and also which future markets you're trying to target. Some of these other countries, we do a lot of filings in China nowadays and in Korea. China is improving a lot, so they've come a long way. Korea typically is pretty good, but again, this is a business decision because it's going to cost a lot of money to file these foreign applications. You kind of have to see, okay, based on the technology and all of these, based on the legal system of the country, where really I should pursue, and maybe it would be worthwhile saving the money that you would spend on foreign filings to file additional U.S. applications and U.S. patents because U.S. is the biggest market. So with that, questions?